Thank you. This will be the Thursday meeting of the House Judiciary Committee. We have several bills and matters I want to make as far as announcement. The first announcement is that we have a invitation for a committee dinner put on by the State Bar. It will be this coming Tuesday evening at McKendrick's Steakhouse up in the perimeter area. Isn't that a nice place to go for that? Tom and I know we go there a lot. Guess who picked that one out, Tom? But it'll be starting at 6:30, dinner at 7. So please mark your calendars if you have not done so already. There's an announcement also in your own package. Yes, you got something?
For the meeting.
For the meeting. All right. Thank you. We have several bills. I'm going to start out, I believe, Mr. Jacobs, you got probably what's going to be the one taking the most time, do you think?
Absolutely.
Is Mr. Bearden here yet?
No.
Tim Bearden's not here? Okay. He said he'd be a little late.
He doesn't make that.
Miss Sims, I know I saw her earlier, and she had, there you are. Miss Sims, come on around. We'll take up House Bill 197's. I know you've got a little bit of a tooth problem, and I want you to be able to get up early so you don't have that develop more of a problem for you. This will be, ladies and gentlemen, House Bill 197, and I'll get my copy up, hopefully.
This one.
Yep, that's a note. Have you got a copy of your bill?
The LC and the...
Yeah. We're looking at LC 294678S.
352186S.
We need to get, is this the right one?
Yes, sir. That's the one that
Came out of
Jill
committee?
sent to me. Yes, sir. We sent the changes. Did you guys see what council after you finished the meeting?
Yesterday.
Okay,
I wasn't
okay.
in the meeting.
Okay.
Usually I table, so you have it from Jill as well.
Okay.
I think what I may want to ask you to do, I'm sorry, is hold up on your bill for a few minutes until we get Ms. Travis here and get the
Okay.
confusion cleared up on that.
Thank you.
In the meantime, what we'll do, I know I've got Mr. Atwood here with 261. If you will, I'll let you slide over if you would, Ms. Sims, and we'll get Mr. Atwood with House Bill 261.
Thank you, Mr. Chairman. With this should be LC 211133S. It's a committee substitute to House Bill 261. Yesterday we had Lieutenant David Barnes. He was SWAT team commander up in Dunwoody. He is not able to be here today, but with me I have Representative Tom Taylor, who's supportive of this. He covers Dunwoody and has actually sent some officers to training that relates to this piece of legislation. What this is, sir, is, and members of the committee, it's an amendment to Code Section 501872, which relates to when public disclosures of public records are not required, specifically relating to records, the disclosure of which would compromise security against sabotage or criminal or terrorist acts, and the non-disclosure of which is necessary for the protection of life, safety, or public property. And it's limited to several areas. The only addition we're making is on the second page, which is subparagraph 5, records of any government-sponsored programs concerning training relative to governmental security measures, which would identify persons being trained or instructors, or would reveal information described in the preceding subparagraphs. By way of description, in addition to having served as a magistrate judge and attorney, I also spent 28 years as a federal agent. I have been an adjunct professor at the International Law Enforcement Academy in Budapest, Hungary, those of you that were not in the subcommittee meeting. And I have trained officers overseas and brought officers over here to be trained. We've had some concern that identities of these officers would be revealed and compromise them in some form or fashion. The problem, what we've done with this is we work very closely with the First Amendment Foundation, spoken with the Georgia Press Association, and worked closely with the Attorney General's office, and we are happy with this with this committee substitute, we believe that it protects the officers while at the same time only being as broad as absolutely necessary. We would still, if, for example, a press person wanted to get access to the financial records, how much does this particular program cost, and that sort of thing, they could still do this.
Mr. Taylor, excuse me.
Yes, for those who were in the subcommittee yesterday, we had our SWAT team commander, Lieutenant David Barnes, who's participated in counterterrorism training in Israel here yesterday, and I know Chairman Lane and Representative McKillop heard some of that testimony. Basically, what we're trying to accomplish here is to make sure that folks who train in specific counterterrorism tactics with foreign governments, the role of law enforcement has changed over the past decade, where police are participating in a lot more homeland security type activities. Just feel that the identities of these officers and specific tactics and training programs should not be revealed for national security reasons. As a retired intelligence and counterintelligence officer, I can tell you that having trained overseas and trained foreign agents here, giving away identities, giving away sources and methods, as well as tactics, it would be harmful to the program. It's a very narrow bill. As Representative Atwood explained, it doesn't cover up anything. It just protects some identities of folks that could be targeted.
All right, thank you. Questions of the committee to the presenters? Do we have any questions? Let me just clarify for my own understanding about the agencies that are involved here. Which agencies, as far as state agencies?
There are primarily local law enforcement agencies. We've had people, for example, from Dunwoody Police Department that actually have gone, in some cases, to Israel and trained.
Yes. But they go through the training. We're looking where they go actually to a training facility.
They go to a training academy overseas, and we in turn accept them here. On the federal level, we have 4 ILEAs, International Law Enforcement Academies, in Budapest, Hungary, Bangkok, and those sort of things. And we do the same thing when I was with the federal government. But these are programs, these are grants and that sort of thing that will allow them to go over and do this training.
Okay, I'm looking for the access of records. The access will be at the local government level, where, let's say, someone filed a request for open records, and in the open records it discloses that John Smith, who is an officer with the Dunwoody Police Department, is on a military leave, and it was going to specify what he's doing.
Well, it could specify that he's involved in training. It would not reveal who he is,
okay.
and it would also not reveal any of the relevant information in the previous paragraphs, being the such things as security plans, vulnerability assessments, any plan for the protection against terrorists and other acts.
That's my point.
Yes, sir. And it would also possibly be on the state level.
That's what I'm trying to get to. We can only do things that protect state records or local records,
yes, sir.
shall we say. If this is involved in something that's a federal record or military department record, we won't be protecting that. I'm just trying to say, where is it going to be disclosed in a state document? The person that we're talking about, Mr. John Smith from the Dunwoody Police Department, is doing a specific type of work or training.
Some of these come through state programs, such as at colleges. We have those, I understand, and I think you've also, your folks have also received grants.
Yeah. You got it.
Yes, sir. Basically, a lot of municipal police departments are training in this now. I know Dunwoody, Sandy Springs, a lot of the state agencies, Georgia State Patrol, GBI. So those would come through the agency that person works for typically. But there's also the association here called GILI, which is the exchange program actually between Georgia and Israeli police departments to reciprocal training. We train some of them here. They train some of ours over there. So wherever that record was kept, the officer's personnel record, say, okay. Whether it's GBI, State Patrol, or a local or county police department.
That's back to the local.
Yes, sir.
This is all, but again, it could be through the association, which is in Georgia's GILI, is the acronym, where they could request the names of, tell us the last 500 officers that came through this program, and their particulars.
Okay. Thank you very much. Any further questions? Do we have anyone else who would like to speak either in support or in opposition to House Bill 261 in the audience? If not, we will close off further public input, and the bill is now in the rest of the committee. Do we have a motion?
Pass, Mr. Chairman.
Have a motion on due pass House Bill 261 as well as a second. Do we have any further discussion? Any discussion on the motion? Any amendments to the bill? There being none, we'll call for the main question, which is a due pass to House Bill 261 as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you,
Thank you,
gentlemen.
Mr. Chairman. Thank you, members of the committee.
Oh, we do well.
Sandy here.
Do we? Yeah. Mr. West, I'm going to call you for your bill, and you can remain in your seat. Oh, this will be House Bill 339, the emergency powers. Yes.
Thank you.
Let me get your mic on. I'm sorry. There you go.
That's all right. Thank you, sir. This bill is a bill that made it through this body and through the House last year, made it to the Senate, and then died for failure of coming out of rules. The bill amends Article 3, Chapter 3 of Title 38. This is essentially rectifying a problem that removes some uncertainty and potential confusion as to filing challenges to public health emergency orders issued by the Department of Health, and also clarifies some the appeal process, as well as extends the declaration of a judicial powers emergency to be commensurate with that of the governor's declaration of a public health emergency. If you will, the bill is before you, and turning to page, or you can look at lines 39 through 41. On those lines, you'll see that what has happened here is that the Court of Appeals is no longer a venue for challenging a public health order. Now it will just be the Superior Court of each county and the Superior Court of Fulton County for filing challenges to those public health orders, such as a quarantine order or a vaccination order. The other change is lines 58 through 64. I'm sorry, those 57 through 58 will take out the ambiguity as to the jurisdictional confusion concerning appeals of those orders. So if the Supreme Court makes a decision, a Superior Court makes a decision, then the direct appeal of that order will be to the Georgia Supreme Court as opposed to the Court of Appeals. And it clarifies that. It also requires that the appeal be direct, be immediate, and that it authorizes the court, the Georgia Supreme Court, to suspend any time limitations for filing briefs. On lines 74 through 82, you'll see that there's a change to the definition of an authorized judicial officer. Before, the law specified both the Chief Justice of the Georgia Supreme Court and the Chief Judge of the Georgia Court of Appeals as having that authority. In dealing with statewide appellate decisions, the Chief Justice of the Supreme Court should be the only person making those, serving in that capacity as the authorized judicial official. And so that is a change you'll see there at line 77. In Section 3, lines 88 through 91 is where we have an extension of the duration in which the Chief Justice of the Supreme Court can declare a judicial state of emergency, so that it would be commensurate with the same time period that the governor calls for a statewide public health emergency. And so that would line those up together. Presently, it's for 3 30-day periods maximum.
3 30-day periods?
Periods maximum presently.
And as I understand the law, even currently, is turn it off. If you got a phone on, I appreciate you turn them off if you got them in here. the fact that the emergency can only be during the time that the governor has declared an emergency, correct?
Yes, sir. That's correct.
And although somebody questioned the veracity of having an emergency, the legislature has a right to stop the emergency if it's necessary.
That's correct. The state law, as it is right now, the General Assembly can step in and declare a cease to the state of emergency declared by the governor.
All right, thank you, sir. Any questions of the presenter?
Mr. Chair, if I might add, Mike Caro is here. He is with the Judicial Council of Georgia, and they are supportive of this legislation.
Right. Thank you, Mr. Caro. Glad to always see you here. Any further questions of the presenter? If there's not, is there anyone in the audience who would like to address the committee on House Bill 339? This is the same bill exactly as we had come through last year, I believe, is it not? Or has it been
I think with the one exception that we have extended the time period to cover that with the governor.
Okay. Thank you. No further questions. We'll close off our further person wish to speak to the bill, then we'll close off further public input. The bill is now in the breast of the committee. Is there any discussion among committee members? Any questions? Not, the chair will entertain a motion. We have a motion do pass. It's been seconded. Do we have a discussion on the motion? Do we have any amendments to offer? There being none, the chair will call on the main question, which is a do pass to House Bill 339 as presented to the committee. All those in favor signify by saying aye.
Aye.
Opposed, like sign. We have do pass. Do we know anything about when Ms. Travis is going to be here? State ethics. Okay. Ms. Jacobs, I'm going to go ahead and call on your bill because we do need to still wait for her on Ms. Travis on a couple of bills here. And Ms. Sims, yours is unfortunately one of them. Until we have her here, I'm kind of reluctant to go forward. We'll call for House Bill 110. Mr. Jacobs.
Thank you, Mr. Chairman. Bring before the committee House Bill 110. House Bill 110 is a uniformity bill that is aimed at standardizing the practices of local governments with respect to vacant property registries and foreclosure registries that have been set up to address code enforcement problems in these local communities. We've dealt with this issue in judiciary on prior occasions where local governments have, counties and cities have proposed, and this committee has considered various provisions to help identify who owns a piece of property for code enforcement purposes. After all of that, some local governments have begun setting up a solution of their own, and unfortunately there are currently 9 of these registries around the state with more jurisdictions considering setting them up. Unfortunately, they're all setting them up using different standards, with collecting different information, different filing fees, different penalties, and so on. And so the state has an interest in standardizing these foreclosure registries, and that's what House Bill 110 does. I'll kind of hit the highlights of the bill, and then yield for any questions from members of the committee. First, there's a definition section in subsection A, and the key definition there is the definition of vacant real property. We're, with that definition, in essence, creating a menu of different purposes for which local governments could create a registry. It would either be for uninhabited property where there's no evidence of utility usage and it's not being actively marketed for sale, lease, or rent. I am going to present an amendment to clarify that language a little bit more. Partially constructed or incomplete and does not have does not have a valid building permit, or a foreclosure hook. So, and a couple of jurisdictions are doing foreclosure registries. So if you foreclose on a piece of property, you have to register it with the local government. DeKalb is one, and I believe Riverdale has either done one or is looking at one that is hooked to foreclosure. We've defined each of those hooks in A through C, and we've defined each of those hooks in A through C, and then we have said that local governments can choose one of them, they can choose two of them, they could choose all three of them. It's in essence a menu from which local governments can choose. B is subsection B is the language that says that you can set up a vacant property registry using the definition that I just explained to you, and it is intended to, and we'll have an amendment to clarify this language a little bit more. It is intended to provide some level of preemption of local government ordinances that do not conform with the statute as you have it in front of you. Subsection C sets forth the information that is to be collected, and subsection D provides that the Department of Community Affairs can promulgate rules and regulations to add information to that list. They can also promulgate, and it's permissive, they can promulgate a form for local governments to use, and if a local government does use, if the department does promulgate a form, that shall be the form that is used by every local government in the state. E is a provision that was added fairly late in the subcommittee process, and by the way, I should add, this bill has been through several subcommittee hearings, but E is a provision that was added relatively late in the subcommittee process, and it says that if you foreclose on a piece of property, or you don't go through the foreclosure process, but you accept a deed in lieu of foreclosure, and the information set out in there on lines 46 through 54 is included on the deed under power, and you file the deed under power within 60 days with the clerk of Superior Court of the transfer of the property, and you provide proof of your deed, you provide a copy of your deed and proof that you filed it, either a receipt showing that you paid the filing fee or a date stamp, you are exempt from any registration requirement pursuant to the statute. That's important because, well, the key for local governments is that they want to be able to collect this information, and we're helping them collect the information. But the state, I believe, has an overriding interest in making sure that title to property is perfected, that these deeds are filed, and so first and foremost, a thing this bill does is gives folks who take property, or entities that take property pursuant to a deed under power or deed in lieu of foreclosure, to get those deeds filed, and thus they would be exempt from any kind of registration requirement as long as the information that the local governments want anyways is reflected on the deed. There are various other provisions in the bill, but those are the core provisions. There are various other provisions in the bill that deal with how this statute would interact with other statutes, making it clear that a county that sets up one of these registries can't require registration within a municipality unless there is an intergovernmental agreement between the county and the city. There is a penalty cap. There's a provision that requires that the fees that are charged for a registration filing be calibrated to cover only the costs of maintaining the registry. So that is House Bill 110 in a nutshell. I do have at the appropriate time, at least, and I'm sure there will be additional amendments, but I do have 4 amendments that are in folders that are issues that came up between the subcommittee meeting and this meeting that I'll offer at the appropriate time, Mr. Chairman, but that is House Bill 110 in a nutshell.
Yeah, we'll address those with your presenting the amendments. We have a few signed up for House Bill 110. Mr. Bruce Bowers. Yes, sir. Have a seat and give us your name and who you're representing.
Mr. Chairman, members of the committee, my name is Bruce Powers. I represent DeKalb County. I will confine my comments to one line of the bill. That is line 73. Particular words, a county or municipal corporation shall not require registration. My concern is as follows. In effect, the bill establishes two different tracks related to vacant real property. The first is the registration requirements in subsection C. The second is what I think of as the deed track, which is in subsection E. And by that I mean that property which is defined as vacant real property, if it is transferred pursuant to something that goes through the deed room, in effect, then under line 73, that property shall not be required to be registered if certain things in lines 80 to 85 happen. Here's my specific concern. Since it is not required to be registered, but it is not deemed registered, my concern is that subsections F, G, and H may not be applicable. In other words, if there's a subsequent change in some of that information, the change only applies, as written here, to registered property. For example, on line 87, an ordinance or resolution establishing a registry pursuant to this code may require a registered vacant real property. And again, it's not registered under line 73 if it goes through the deed room, in effect. So I believe that the intent is that the subsections related to registered property under subsection C are also intended to apply to the property that comes through subsection E, but it does not specifically say so, and the language actually makes it confusing as to whether it does or not.
Thank you. Any questions of members of the panel committee on Mr. Bauer's concerns? No one? Let me ask a question, Mr. Bowers. I'm trying to follow what you were reading there. You're saying that under the language of section G, no, I'm sorry, section F, you're saying this gives a broader meaning than what you felt as being the limitation under E?
No, sir. Let me
back up again.
Let me try again.
All right. Sorry.
Property that is where the information that the county wants, property that comes through subsection E. In other words, it comes through.
That's recorded deeds, the deed of sale, or whatever you want to call it.
Right.
All right.
That is under 73,
foreclosure.
Not subject to registration. Okay, so it is not registered.
All right.
Subsections F, G, and H particularly relate to changes in information, application for renewal, payment of fees and penalties. They refer to registered vacant real property, which again, subsection E, anything that comes through there is not registered vacant real property.
All right. Mr. Jacobs.
Mr. Bowers, if we were to strike on line 87 the word registered, would that not address the concern you just stated? Because it's still a vacant real property owner, okay? So you can, by ordinance, require them to update the information that's specified in those paragraphs, whether they've used either track, I would think. And furthermore, then if you go to really the only other relevant provision, I believe, subsection I, starting on line 100, which is the penalty provision, that says it's either failure to register or failure to update the information specified in those paragraphs. So they're providing you the information required in the paragraphs. If we take the word registered out of line 87, I think that might address the problem.
It might. My suggestion, which again I'm not trying to expand the scope, would be to say somewhere in 73 through 75 that such property is deemed registered for the purpose of this section.
Or
Okay.
As a further thought on paragraph F, the beginning of it, subject to the limitations of subsection E of this code section, comma, an ordinance or resolution establishing a registry.
I believe that takes care of F. Again, I think this is F, G, and H. And again, I'm not trying to expand. I just want to make certain that that changes that may happen as a result of something that comes through E are captured.
Thank you.
That the agency requirements are. That's it. That is the goal of my suggestion.
Thank you. Mr. Welch?
The waive.
Pardon me?
The
You waive, okay. Mr. Powell, that's you? Yes, sir. Mr. Powell.
Another alternative, Mr. Chairman, may be to change the reading of subsection 2I under C to read the entire deed under power of sale or entire deed in lieu of foreclosure shall be deemed to comply with such ordinance or resolution, and the payment of any administrative fees pursuant to the code section shall not be
Give me a
required.
line section. I
All right,
follow
73.
Line 73.
Yeah.
Okay.
The entire
2-1.
deed, the entire deed under power of sale or entire deed in lieu of foreclosure, same shall be deemed to comply with such ordinance or resolution, and the payment of any administrative fees pursuant to subsection H of this code section shall not be required. It would accomplish the same thing.
As I hear that, I respectfully do not believe so, because again, it says it shall comply, but it doesn't again contain it would not be captured for F, G, and H purposes for further action as if it were registered. Updates to information.
Well, if the code section requires that it be registered, and it says it shall be deemed to comply with that code section, then it's deemed to be registered. Or, I mean, you could say it's deemed to be registered and complies with such ordinance or resolution. Just a suggestion.
All right. We'll weigh that in a moment when we get into the discussion about the bill with the committee. Is this Mr. McKillop?
Thank you. Thank you. I appreciate your presentation. You represent DeKalb County? Do y'all have one of these now?
Yes,
Is that what I understand?
DeKalb has had a registration for a number of months, yes, sir.
And do you have penalties for not registering?
We do, yes.
What are they?
The penalties are $1,000 a day.
And does that include not only foreclosures but deeds under power and also simply properties that are vacant? Like I've owned a house for 10 years and I go 60 days without renting it or marketing it for rent. Does that have to be registered in DeKalb County?
Sometimes I have to. Yeah, again, our ordinance today is a foreclosure ordinance only. And so, as I understand the question, no, sir, it would not. I will point out that the county has never yet collected a penalty. The penalty is
Assessed the
clearly-
penalty.
Sir?
Difference between assessed and collect. They never assessed the penalty.
Pardon me, yes, sir. They've never assessed a penalty. Have not done it, and have, whenever it's been raised, have waived it in the interest of collecting the information. That's what we want.
Right. Can I follow up, Mr.
Sure.
Chairman? Now, last year we passed a bill that required folks who did foreclosures to file that deed within, I think, 60 days. 90 days. And we had some debate on that, and we had some debate about whether to add a penalty provision to it, because at the time there was no requirement in the law to file a deed at all in Georgia. In fact, there still is none other than this. Have you seen in your work for the county a reduction in the problem based on the foreclosure deeds, based on the law that we passed last year requiring the foreclosing entity to file those deeds?
As I understand what you're asking, no, we have not, because again, the problem that is faced by the county is a property that is subject is about to be foreclosed on is typically not very well maintained. Then we have the foreclosure, and 90 days later we have the information as to who is the owner after the foreclosure. And at that point, assuming that we have all the information necessary to track down who is the owner, we were able to take action based on code violations that have occurred at least in that 90-day period, if not prior to that 90-day period.
In order to file the foreclosure deed, don't they have to file a PT-61 form with the new owner's name and address?
You are now honestly going beyond my ability to answer the question, frankly. I have someone from the county here who...
Come on up with
Chairman,
your light. put on the other chair on the other side of you, because we've got a mic there that she can also, one of you get over there. I think he's playing musical chairs with you now. It's a trick.
Good afternoon, members of the committee.
Give us your name and how you're employed, please.
Hansa Clark, DeKalb County. The issue we have with the deeds being filed, because there's no penalty, what we've been seeing is a trend where the deeds are not filed within 90 days. Sometimes they're not filed at all. And usually what we're seeing is that those deeds may not be filed until someone actually purchases the property.
Do you think that the same problem could be alleviated by simply adding a penalty provision to the failure of a foreclosing party to?
Possibly so.
Did you see any uptick in the filing of foreclosure deeds after the law we passed last year?
No.
Thank you.
If I may add to that, again, our ordinance was enacted in October, and to give you an idea of the scope, there are currently 1,500 properties in DeKalb County advertised for foreclosure, and last month we processed over 400 properties on the registry. So it is a very real issue, and with a fairly significant scope.
I understand. Thank you.
Thank you. Yes, no ways, Mr. Maddox Ways. Let me take a moment of personal privilege, and I've got to recognize, because he's sitting behind the big column there, but we've got Judge Steve Goss with us from Albany. Glad to have you with us. Any other judges with us? I couldn't tell if there are, but we're always glad. No one else? Anybody? All right. They sort of sit quietly. Two magistrates, right. Okay, we're going to have a bill y'all can talk about later. Glad to have all of you with us. We have others, I think one other person who would like to address the committee. Have any further questions of Mr. Bowers or Ms. Clark? Excuse me. Pardon me, Ms. Clark. If they're not, we have one other person, Mr. Stevens from Gwinnett County. Mr. Stevens, please come forward and let us hear your comments, sir. Pull that mic around. The one on your right would be the better one. Yeah. Okay. There you are. Thank you.
Thank you,
Give us your name
Chairman.
and how you're employed.
Members of the committee, I'm Van Stevens with Gwinnett County. I have just a couple of comments, and primarily they concern lines 20 and 21 of the bill, dealing with the definition of vacant real property. By the way, the language, we appreciate all the work that's gone into crafting the language of this bill. A couple of things that occurred to us is that, first of all, when on line 21, talking about a building or structure that has been uninhabited, it may be helpful to add by an authorized occupant. In other words, to prevent the situation where someone that's unauthorized, as we've seen in the news this week, I believe in Gwinnett County, is occupying a house. We wouldn't want that to prevent us from being able to regulate the registration of that. In other words, a squatter, something of that nature. So we would suggest after uninhabited by an authorized occupant, some language to that effect.
All right.
The other issue deals with the, and I understand that there may be an amendment on the same line, the language dealing with whether the property has not been actively marketed for sale, lease, or rent. It's possible that an owner might put out a sign in front of the property and not have really any legitimate means of contact or for us to be able to get in touch with that person. And we would just suggest that after rent, the language be added with the information required by subsection C of this code section being conspicuously posted on the vacant real property.
I think we do have an amendment that may resolve that question.
Thank you. And the only other point we appreciate in Gwinnett County, the language in subsection B that includes the authority to require a registry for commercial property. So we do thank you for that. And I have nothing further on the bill unless you all have questions.
What language are you speaking of on the ability to registered commercial property?
It's actually in B, lines 33 through 37. When read in conjunction with the definition of vacant real property.
Okay. Thank you. Any questions of Mr. Stevens by members of the committee? If not, we appreciate your taking your time and coming forward to be with us today.
Thank
you. Do we have others who would like to address the committee? I don't think anyone else has signed up, but we're open. Mr. Hatcher?
Sure, and I appreciate that. I had not intended to speak, but this gentleman's comments do
Have a seat.
affect my membership.
Use your
I
right
represent
member and
the Georgia
right mic,
Association
the right mic, so you can give us who you're representing and your name.
Thank you, Mr. Chairman. Keith Hatcher, representing the Georgia Association of Realtors, and I just wanted to bring to the attention of the committee the amendment as suggested by the previous speaker, I think would create some complications for my membership in that the signs that we typically put in the yard do not contain much of the information required under this act. We don't, for example, list the owner's name, phone number, fax number, those sorts of items. But we do believe that the information we provide in our signage is more than adequate to contact an individual to serve notice that the property is not up to code.
I think we've got an amendment that may address that.
Thanks, sir. Appreciate it.
Sure. Thank you, Mr. Hatcher. Anyone else wish to speak to the committee? Has not signed up, we'll be open to it. If not, we will close off further public input. The bill is now in the breast of the committee. Do we have discussion, first of all? If not, the chair will entertain entertain a motion, excuse me. Do we have a motion?
Due pass.
Motion is due pass. We have a second? Second. Have discussion on the motion. Any amendments?
Yes, Mr. Chairman.
We have amendments. State your amendment.
And, well, let me.
I'm sorry.
It's all right.
Pardon.
It appears, based upon what's in your folders and what I've heard here, and one other issue, I have a total of 6 amendments. So let's take these one at a time.
Why don't you do it through the process of going from the beginning of the bill with your amendments and then present them that way?
Sure, that sounds good. And I think I've got them, the ones that are numbered in your folder are numbered, I'm pretty sure, in order of how they...
You have one in the folder. Why don't you use the AM number?
Okay. The first one is AM 291002. I've also hand numbered them 1 through 4 in the upper corner there. It would amend sub paragraph A to deal with a couple of issues. The first is this would appear to apply to any uninhabited structure on a piece of property, including a shed or something like that. And so we've added the words is intended for habitation at the beginning, comma. And then to deal with the signage issue that has been a recurring theme in just about every committee hearing on this bill, we've added language after marketed for sale, lease, or rent with prominent signage posted on such property bearing the name, and I'll make part of this amendment the word valid. So insert valid between and phone number. The name and valid phone number of the vacant real property owner or the individual license pursuant to Chapter 40 of Title 43 representing the vacant real property owner. And, of course, that would be the part of the code that deals with real estate agents and real estate brokers.
All right, that's your first amendment. Do we have any discussion on that amendment? Mr. Welch?
Yes, sir. Thank you, Mr. Chairman. Chairman Jacobs, would it be possible to also amend the amendment on line 2 after the word uninhabited by adding the phrase by an authorized inhabitant as requested by Mr. Stevens?
I'm unclear what an authorized inhabitant is.
Someone who would have permission to be there, as opposed to being inhabited by someone that is just
think, Chair speaking, I think that may be more appropriately addressed when we get to that other issue that was raised by Mr. Stevens. And because here you talk about the listing on the property itself, clarifying there will be a need for a listing.
If I recall correctly, Mr. Stevens was referring to an amendment to lines 21 and 22, and that would be this amendment. Is that right?
I would okay. I think I'm comfortable with that language. I'll accept that as a friendly, well, not a friendly amendment. I'll make that part of the amendment. So, has been uninhabited by an authorized inhabitant.
Hold on. That's one
Occupant.
Let's have one at a time, please.
Occupant. Okay. So, you want me to read the whole amendment one time? Would that help?
All right.
Is intended for habitation, has been uninhabited by an authorized occupant for at least 60 days with no evidence of utility usage, and is not actively being marketed for sale, lease, or rent, with prominent signage posted on such property bearing the name and valid phone number of the vacant real property owner or the individual license pursuant to Chapter 40 of Title 43, representing the vacant real property owner.
Questions, Mr. McKillop?
And I agree with the purpose of what's going on here. Isn't it true, as opposed to working through authorized occupant and definitions thereof, it might be easier to say has not been lawfully inhabited for at least 60 days? That would be my suggestion. That would prevent squatters and trespassers. Rather than using the undefined term of authorized occupant. Who authorizes them? What is an authorized?
Has not been lawfully
inhabited.
I like that phrase better. Would you accept that as the proposed amendment to your amendment? Has not been
lawfully
inhabited. Take out un.
Let me withdraw the amendment and restate the amendment.
All right.
Okay? Here is the amendment. Is intended for habitation, has not been lawfully inhabited for at least 60 days with no evidence of utility usage. Does that all flow? And is not actively being marketed for sale, lease, or rent with prominent signage posted on such property bearing the name and valid phone number, and the balance would be what you see here on the page.
Right. Did you have another comment, Mr. Welch? Or? All right. Anything further, Mr. McKillop? All right. Anyone else wish to comment on the proposed Amendment 1, Jacob's Amendment 1, AM 29-1002? There's no objection to the amendment, then we'll accept that amendment. No further discussion on the amendment. We're going to vote amendments one at a time. And the vote will now be on AM 29-1002 amendment as amended. All those in favor signify by saying aye. Opposed, like sign. Motion carries.
Second amendment is on lines 28 and 29, and this was an amendment that was inserted in the last subcommittee meeting, and it was inserted in the wrong place. We're trying to exempt out property that multiple unit property, but we don't want to exempt out, say, a townhome where you've got two different a duplex where you've got two different owners and one side is falling apart and the other side is properly maintained. What we've done, what the amendment does is flips with common ownership and containing multiple units. And it would read, such term shall not include a building or structure containing multiple units with common ownership that has at least one unit occupied with evidence of utility usage. Period. A county.
Then continues on.
All
right. Any further discussion on the amendment number 2 Jacob's amendment number 2? If not, we will have a motion on the amendment.
So moved.
Been moved. Do we have a second?
Second.
Moved and second. Any discussion on the amendment? Call for the question. All in favor of amendment number 2, Jacob's amendment number 2, 1007, signify by saying aye. Aye. Opposed, like sign. Motion carries. Next amendment.
The next amendment is actually numbered as amendment number 4 in your folders, AM 291003. This amendment is offered because we removed a paragraph in subcommittee, and in removing that paragraph from subsection B, we made it unclear as to whether this statute preempts local ordinances or whether it grandfathers in existing local ordinances. And so the amendment is aimed at making it clear that our intent is to preempt existing local ordinances. So on lines, it would replace line 37 to state, by general law, comma, and all existing county or municipal ordinances or resolutions to the contrary shall hereby be preempted, semicolon, and.
All right. Does everyone understand the amendment? Is there any questions or discussion about the amendment number 4, AM 291003? Do we have that proposed as an amendment? Chair will accept the motion. Been moved. Do we have a second?
Second.
It's been moved and seconded. Any further discussion on the amendment AM 291003? Chair will call for the question on the amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Next amendment.
Next amendment is not in your folders. That would be on line 53 to right after the paragraph number 5, insert if available, comma, and then lead in with a lowercase r. The reason for that, of course, is that certainly for purposes of the deed issue, and as well just for registration purposes. In many cases, you're not going to have a deed book and page number at the time that you are required to register. So the amendment would be to insert if available, comma, and then start with a lowercase with the r.
All right. Does everyone understand the amendment? I have a question on the amendment by Mr. Powell.
Just a question for the author. If someone's required to register and you say that if available, and it's not then available, then I don't have to furnish it, but it's not clear that when it becomes available that I might thereafter have to either amend or furnish that additional information. So my question is, would it be better to say when available instead of if available?
Well, the question is, would we want to require updating of this information when it becomes available or not?
I think so.
Okay, then it.
I mean, but that's up to you. But that would be my suggestion, because otherwise, I could furnish what information I had, and then I've got no further obligation.
I'll withdraw that amendment and restate it as when available, comma, and then lead in with a lowercase r.
Everyone understand that? Do we have any? You not, Ms. Travis. 53. Yes, ma'am. Recording. Yes, ma'am. Further discussion? Is it? You have a question, Ms. Evans?
I do. I'm a little bit concerned that when available may somehow be tied to when it's available, sort of meaning the same thing as if available, and I'm wondering if it might be better to say at such time as it becomes available. My concern is that sometimes when you say where available, it means if available, and when available could to some people mean that the same thing. Just a concern.
That's,
What's your thoughts, Mr. Jacobs?
I'll withdraw the amendment. Would you like to? I think that should be an Evans amendment. Would you like to state an amendment?
State it.
By on line 53 after subparagraph 5, inserting the word "at such time as it becomes available," comma, and then leading in with a lowercase r.
As it becomes available, comma.
At such time as it becomes available,
At such
comma.
time, excuse me.
Mm-hmm.
I'll second that amendment.
Just a minute. So read at such time as it becomes available, comma, recording information, etc. Correct?
Yes.
Make that in the form of a motion.
Yes, sir.
So move.
Yes.
Second.
Second.
Moved and second. Any discussion on the Evans motion? I'm sorry, motion amendment. If not, we will call for the question. All in favor of the Evans amendment as stated, signify by saying aye. Opposed, like sign. Motion carries.
There are only two more left. The next one is in your folder, AM 29-1004, Amendment Number 3. And this was an issue that came up immediately after the subcommittee meeting with Representative Evans, as a matter of fact, and that is that it's unclear from the way that paragraph 1 reads in its entirety whether you're exempting the property after the deed is filed, because it says shall not require registration, or whether you're just exempting the person who owns the property. And so I've clarified that language in the amendment by striking line 73 and replacing it with a county or municipal corporation shall not require the transferee to register such vacant real property pursuant to this code section. Then it continues on.
Thank you. Any question by members of the committee of the AM 29-1004 Jacobs Amendment? If not, Chair will entertain a motion. Anybody want to move on that? I'll move. It's been moved. Do we have a second? Moved and seconded.
Oh, I guess I needed to move it.
You can make your own motion.
Well, that's the Lane amendment then.
Amendment. All right, we've had a motion second. Any discussion on the motion amendment? AM 29-1004. Chair will call for the question. All in favor signify by saying aye. Opposed, like sign.
And the last amendment is on line 87, and I believe in reading all of this together that this addresses Mr. Bauer's concern to strike the word registered on line 87.
Read what will be the language of paragraph F.
It would be an ordinance or resolution establishing a registry pursuant to this code section may require a vacant real property owner to update the information specified, et cetera, et cetera. And I think that then requires both information that is collected via the registry and information that is collected via the deed to be updated if that's what the ordinance requires.
All right. Does everyone understand the Jacobs Amendment for line 87, striking out the word registered? Any discussion on that amendment? Do we have a motion on the amendment?
So moved, Mr. Chairman.
And do we have a second? Motion second. No further discussion. The chair will call for the question. All in favor of the Jacobs Amendment to line 87 signify by saying aye.
Aye.
Opposed, like sign.
I have no further amendments, Mr. Chairman.
All right. Do we have any further amendments?
Yes, Mr. Chairman.
Recognize Mr. Maddox.
Thank you, Mr. Chairman. There's a printed amendment in your folder, AM 29-1005, which deals with subparagraph H on page 3, which gets into the cost and assessment of a fee for the registration, and the bill leaves the fee to the definition of what is a reasonably approximate cost of establishing, maintaining, operating, and administration of the registry. The amendment that I propose would be an amendment to line 99, such that line 99 would then read, administration of the registry, period. Such fees shall not exceed $100 per registration.
All right. Any discussion among members of the presenter on the amendment as to that particular amendment? We have Ms. Oliver. Thank you.
I apologize for missing part of this discussion, but in relation to this amendment and in relation to line 103, I must ask, how does this affect DeKalb County's existing registration fees and fines?
He may not know, but I think either Mr. Jacobs or someone from DeKalb County, personally I know too, but go ahead, Mr. Jacobs. Oh, let me get your mic.
I hadn't heard, and as far as my answer to the question, I hadn't heard anybody testify as to any figure as to what it costs to establish. But
well,
in this hearing,
there was extensive testimony on that in subcommittee. I mean, this amendment would affect, under DeKalb's testimony in subcommittee, the level at which the county is currently maintaining its registry in terms of what the county states its expenses are for the registry. They currently are charging $175 to register. So that is correct. Now, I took that language out after talking with the county about the issue, and we do have some language in there that is already a protection that the amount charged for registration may only be calibrated to the cost of maintaining the registry. I intend to oppose the amendment. But yes, there was testimony in subcommittee about that, and DeKalb's current registration amount is $175.
On your other question about line 103, I think they currently have $1,000 per day. Although, as you heard Mr. Bowers testify, that has not been assessed to date by the county.
Again, I apologize for missing that part of it. So, Mr. Bowers didn't address the registration issue earlier today.
Did not.
Is he here still?
We've closed off public input, though, unless you want to move to open it up. Any further? I think you have yours, Mr. Powell.
Just to make a comment, there was also some testimony, as I recall, that some communities also charge an annual maintenance fee. So there was an initial registration fee and then also an annual maintenance fee. So, certainly a limitation of $100 per registration without more would affect, fines or late filing fees, annual maintenance fees, and also the initial registration fee. And though that may be something we want to do, we also need to be aware that it would impact what a lot of communities are doing. And based on the testimony, depending on how aggressive they were, they periodically go out and inspect the properties. They have to track down these owners. They do spend some time doing that. And I don't know that $100 will allow them to recover the time and investment.
You're looking at the annual aspect of it?
Both initial fees and annual fees,
okay.
yes.
The thing, go ahead. You had a question, Mr. McKillop?
No, I have a subsequent amendment.
You do have subsequent. All right, we'll hold up for that. The only thing the Chair will speak on the issue is, I think you may be right, it could be adding on the end of that, not to exceed $100 per registration, annually, period. To address. I have some problems leaving it open. The testimony I heard at various stages dealt with the desire of local governments to use this also in a part of the cost recovery to code enforcement, which I say doesn't fall under what I see to be the registration need that local government have for requiring the property owners to register. If there's something that is being done that is a deficiency under the property maintenance ordinances, that is another area of enforcement and other assessment of charges can be made. And I try to look at what is considered the clerical costs and other administrative costs of actually having someone come in and go through the process paperwork-wise of registration of the property, which is the only thing this ordinance, or this law rather, addresses. So maybe this, to solve the concern if the property stays on the registry more than 1 year, it might be something to consider, having ability to require the continued registration with an annual fee. Further discussion? Mr. McKillop, or did you say you wish to make a substitute motion?
I have a different amendment.
I'm sorry, a different amendment, not to this particular amendment. Okay. We have had a motion, or Mr. Maddox, do you wish to make a motion as to your amendment?
So moved, Mr. Chairman.
It's moved. Do we have a second? Second. It's been moved and seconded. Do we have further discussion on the motion, the amendment motion? Does anybody want to consider the idea of adding the registration, comma, had the word annually? Does anybody wish to consider that? Do not. Okay, there is no consideration for that part of it. The further discussion on the motion. Motion is a motion to amend as to line 99 under AM 291005, the Maddox Amendment. All in favor signify by saying aye. Aye. Opposed, like sign.
No.
The chair is in doubt. The chair will call for a call of hands. All those in favor of the motion signify by raising your right hand. 2, 3, 4. All those opposed? 1, 2, 3, 4. And the chair will break the tie and vote in favor of the amendment. Any further amendments to House Bill 110? Mr. McKillop.
Thank you, Mr. Chairman. In thinking about it, as we talked about the fact that we've just last year made it a requirement to file these deeds at all the foreclosure deeds, and I understand the author will oppose the amendment. I respect that. But I think that it should be the same 90 days that you have to file one of these deeds for the folks that are practicing the real estate law, so that they don't have to keep a registry of which counties are 60 days and which counties are 90 days to file the deeds in lieu. So I would move to amend lines 68 and 81 and change 6 to 9 in both of those lines.
So the motion would be, let's do line 68 first. On line 68, your motion is to amend 60 to 90.
Yes, sir.
Is that correct? Discussion on, will you make that in the form of motion?
Yes, sir.
So moved?
So moved.
Is there a second to it?
Second.
Motion made and seconded. Discussion on the motion. Mr.
Yeah.
Jacobs.
That's what.
We addressed this issue also in subcommittee this morning, as a matter of fact. And you know, the issue is this, and the issue is this: 60 days, 90 days. Okay, and we initially considered actually moving this to 45 in subcommittee. We settled it at 60. But 90 days, when you're dealing with a code enforcement issue in the summer, in particular with grass growing up waist high, is an eternity. And the thinking here is that, you know, we're not placing an affirmative duty on anyone to file the deed. What we're doing is creating an incentive to get the deed filed quickly. And we calibrated the 60 days based on prior testimony that I don't know whether we heard it on this issue or on a different issue, but we calibrated it based upon prior testimony we had received from the credit unions and the community banks in particular, that about 60 days is kind of the length of time it takes them to get the deed filed. So we were looking to kind of balance the code enforcement issue with the business issue of what it takes to get the deeds filed, and in dealing with that issue, both with the local governments and with the banks, we arrived at 60 days. I would oppose the amendment.
Further discussion, Mr. McKillop.
Yeah, and I do respect all those issues. I mean, first of all, I guess I would say that, number one, we did do something about it last year. We made it a requirement of the law that they file we made a requirement of law. They file the deeds. We had the same discussion about code enforcement because that's why this issue was brought to us about filing the deeds in the first place. And last year we came to a 30-day different resolution at 90 days. And I just think it should be consistent. I think we should be consistent across the law. If it's going to be 90 for filing a deed, it should be 90 for filing a deed if it's pursuant to the registry. My other point on that would be if the point is simply to enforce the filing of the deed requirement, we could add a penalty provision to that much more simply. There's much more here than that. It's a lot more information than simply filing a deed, and it's adding a lot of requirements. So I think to be consistent so that people who are practicing this kind of law understand it's 90 days across the board, that's my amendment.
Thank you. And I think, Ms. Evans, you had a button push, did you?
Yes, Mr. Chairman, thank you. I just wanted to add for the benefit of the committee members who weren't part of the 4 or 5 subcommittee meetings that we had, specifically this morning, we discussed this issue and we said we're going to put it in 60 days, and I suspect that if 60 days is not enough time, I bet you will hear about it in full committee, and we haven't heard from any of the stakeholders that 60 days is an unreasonable amount of time, and I would just, it's not about filing the deed, it's about your incentive not to have to register the property.
Thank you. Mr. Welch?
Rhetorical question, but I think I would be surprised if I was the owner of the foreclosed property to learn that I missed the exemption by 30 days when I filed within the 90 days. Just a thought.
All right. Thank you, thought. Mr. Jacobs, last word. You want to say something?
Well, I mean, first of all,
quickly.
Okay. I mean, this
I
don't know that I'm capable of that, Mr. Chairman.
I know.
But to the extent that this provision aids creditors that are filing these deeds all across the state in getting some uniformity, I think, I think 60 days is a much more sensible time frame in terms of doing that. It clamps down kind of the state's interest in getting these deeds filed as quickly as possible. And I will reiterate for the committee that we have heard nothing from any stakeholder, including in fact, it was the banks and credit unions that gave us this 60 days as kind of the outside of what it takes them to get this done. So I would ask the committee not to extend that time period and accept the amendment. And with that, Mr. Chairman, I'll be quiet.
You like 60, he likes 90. Chair will call for there has been a second, I believe, your amendment, was it not? I'm trying to recall now. There was a second. All right. No further discussion on the amendment. The chair will call for the amendment, which is the McKillop amendment, to change from 60 days to 90 days on line 68. All in favor of the McKillop amendment signify by saying aye. Aye. Opposed, like sign.
No.
Chair is not in doubt. Chair believes the motion failed. You want to challenge the chair? All right. You have another amendment? No. Any further amendments? If not, the chair will call for the main motion in question, which is a due pass to House Bill 110, LC 294679, as numerously amended. And you've got all the amendments. All right. All those in favor of due passage signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Now, Ms. Sims, have you seen Democracy in Action here today? We'll call on you to come forward with your bill. This is the Ms. Sims is here on House Bill 197. Thank you. Glad to have you with us today. Let me get your mic on. I apologize. Go forward.
Thank you, Mr. Chairman and members of the committee. This has been a learning experience for me. I'm bringing to you House Bill 197, and the legislation simply mirrors that which was passed 2 years ago on the Department of Corrections. It simply requires that hospitals who treat prisoners in their emergency rooms not to charge a rate higher than what Medicaid pays. The original legislation did not include the Sheriff's Department, so House Bill 197 establishes the parity between the Department of Corrections and the Sheriff's Department relative to the emergency health care treatment for those in our local jails. That's the essence of the bill.
All right. So what you have, if I may first ask for clarification.
Yes, sir.
If there's a person who's incarcerated in a county jail.
Yes, sir.
And that person who is in the jail is struck with a illness and has to be hospitalized, taken to the hospital, emergency room, whatever, there will be the limitation of the charge that can be made to be the same as is charged by that hospital for Medicaid services.
That is correct, sir.
Question. I know municipalities will also from time to time have persons taken to a jail. Do we have this bill to cover those circumstances, or is it just the sheriff?
Well, this is anyone in the in a local detention arena. That is who will be taken. So it could be, of course, in the local jail, but if they are if they are in the local jail, they have emergency, they can be taken.
So looking at your definition on line 12, number 1, detention facility means any municipal or county jail or other facility used for the detention of persons charged with convicted criminals, offenses charged with adjudicated for a delinquent act.
Yes, sir.
Ms. Travis, you're satisfied that this will cover both municipal type incarcerated individuals as well as sheriff county incarcerated? Good. Thank you. Any questions of Ms. Sims? Seems to be a reasonable piece of legislation. We do have a question, I believe, of Mr. Powell.
Yes, ma'am. Dealing with the negotiation of the rates, and I think that's on line 38. And I just question, and somebody that knows more about counties and the authority that sheriffs have may be able to enlighten me. But I'm concerned about nothing contained in this code section shall prohibit a sheriff or a governing authority from negotiating and establishing fees or rates. And I'm concerned about the county being on the hook for paying a rate that a sheriff negotiated without any input or authorization from them, and I'm wondering if this gives the sheriff that authority.
This is why this is coming forward, because they have contracts, Blue Cross Blue Shield, I believe, most of them, but they do have the contracts with the insurance companies. If they choose not to have that, they still have to pay the amount under the Medicaid.
No, I understand that. My question is the authority of the sheriff
to make that
decision and to bind the county and to bind their funds.
I cannot answer that for you.
I can give you some insight, I think, Ms. Powell. You know cases like I do on this point. There's volumes of cases where litigation goes on between a sheriff and the county government as to the use of their funds and who has a say-so about how those funds are being applied. But you also have the obligation, I think, of the sheriff that if he has someone who's stricken with an illness, he must provide medical care to that person.
And I understand, and I don't disagree with that. I have a problem with the sheriff binding the county from the standpoint of the sheriff has to have vehicles. But the question becomes, if the sheriff says, I need 2 vehicles, can he go out and buy them at any price that he wants to, or does he have to go, let the county have some input into the bidding process or to the selection of the appropriate vendor?
All right. Thank you, sir. Mr. Welch, is that yours pushed?
Yes, sir, Mr. Chairman. And to the extent that there's a problem here, would it be helpful to add at the very end of the sentence on line 40, to the extent authorized by law?
Makes total sense.
Or maybe strike the section.
Mr. Chairman, if I may.
Yes, sir.
And what may resolve this, because the governing authority is defined as either municipal or county at the outset. And maybe if we just take the sheriff out of line 38, because you know, if the county authorizes the sheriff to negotiate for them, that's fine. But the county governing authority would have the authority unless they delegate it.
Why we need that? I think you already got law that addresses the obligation or rights, responsibilities between the sheriff and the county government for determining fiscal obligations and payments of money. So maybe the question is we don't need paragraph C at all. Thank you. Thank you, Ms. Sims. Anyone else wish to address the committee on Ms. Sims' bill, which is 197? Ms. Nesbitt? Only if there's a pound cake involved. Have a seat. Identify who you're with.
Deborah Nesbitt with the Association of County Commissioners, and we support this legislation. A lot of the sheriffs do have contracts with the providers. They can't contract for more than they're budgeted by the local governing authority. So I don't really know that that's a problem, because in some counties,
I don't think it's needed.
Right?
It adds something to it that's already established as law.
Right. So I don't know that really makes a big difference. Any other questions regarding the county part?
Glad to have you with us. No further. Anyone else wish to address the committee? Yes, sir. Please do. Give us your name and who you represent.
Thank you, Mr. Chairman, members of the committee. I'm Ethan James. I'm of the Georgia Hospital Association, and we do appreciate Representative Sims bringing forth this legislation. It's actually very similar to a bill from 2 years ago, HB 464 from the 09 session, that addressed the same issue on the statewide level with the Department of Corrections. We had worked through the subcommittee process and had worked toward an amendment, I believe beginning on line 26, if I'm working off the correct copy.
Right. Do you have a copy of your amendment?
I believe Representative Jacobs does.
Jacobs has it? Okay. What does your amendment seek to do, if you want to talk to it?
It would ensure that the hospitals that do have a contract to provide these services with the governing authority or its agent, because a lot of times, as it was pointed out, the governing authority does work through an agent to establish these contracts, oftentimes with, I think it was mentioned, Blue Cross Blue Shield. It would ensure that those contracts would not be nullified and give the hospitals kind of the a poor bargaining position as they move forward.
All right.
And I hadn't noticed it before, but perhaps on line 38, when it does say nothing contained in this code section shall prohibit a sheriff or governing authority from negotiating, establishing fees or rates, maybe it should say again there, a governing authority or its agents.
We don't want to say anything there.
Yes, Mr. Chairman.
Bottom line. I think, as I was saying earlier, there's already well-established law dealing in this area, and all we're going to do is, by putting this paragraph in there, is muddle it up.
Yes, Mr. Chairman.
We'll let the Superior Court judges resolve that all the time, don't we, Mr.
Thanks
Goff?
so much. I
Judge Goff.
Happy to answer any questions.
Thank you.
Thank you.
Any further comments of anyone who wishes to address the committee? If not, the bill is now in the breast of the committee. Do we have any discussion? First of all, let the chair, no discussion. The chair will entertain a motion.
Do pass, Mr. Chairman.
A motion do pass. Is there a second? It's been seconded. Are there any proposed amendments?
Yes, Mr. Chairman.
Mr. Jacobs.
And I've handed out this amendment to members of the committee. It would be to strike the language on lines 26 through 29 and replace it with the language that is reflected here on the amendment. That's
LC 294778S.
Well, that's the LC number.
That number? Okay,
it's the language that's set forth after the
you got it, Ms.
letter
Travis? Ms. Travis, do you have it? Okay.
And this is clear to me. Is it clear to you, Ms. Travis?
So your motion will be to strike on lines 26 through 29, correct?
That's correct.
And insert this as an amendment.
Correct.
You make that in the form of an amendment?
I do. So move, Mr. Chairman.
Got a motion to amend. To have a second? Second. It's been seconded. Any discussion on the Jacobs amendment? If not, the chair will call first on the proposed Jacobs amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. The motion carries. Are there any further amendments? Yeah. Oh, excuse me. Get your mic number for me.
Mr. Chairman, I move to strike lines 38 through 40.
Correct. We are asked. The motion is from Mr. Welch to amend by striking what is paragraph C on lines 38 through 40. Do we have a second to the Welch amendment? Second. It's been seconded. Any discussion on the Welch amendment? There being no further discussion, the chair will call the question. All in favor signify by saying aye. Aye. Opposed, like sign. Are there any further amendments? We have no further amendments. The chair will call for the main question, which is House Bill 197, as amended as a committee substitute. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. The motion carries. Ms. Sims, thank you for your tolerance in waiting for us to get to your bill. The next bill we have, I believe, is get my sheet up here again. I'm sorry, I lost my spot. 149 or 245. Well, Bearden's not here. Is it? I'm sorry, hiding in the corner. Well, whether he's here or not. That's right. Mr. Bearden, I will take you next in the order of, who's the other one?
Representative Kidd, HB 245.
Seniority would take it. Okay. That's right. It gives you a chance to see democracy in action here.
Boy, some days I miss this room.
Some days.
Tell us what your bill is and what it seeks to do, Mr. Bearden.
Thank you, Mr. Chairman. I'm going to be carrying this bill for Chairman Jacobs. This House Bill 149, and let me just give a great deal of gratitude to Chairman Jacobs for all his hard work on this bill, because this thing is truly going around the world, and I think we could have a very good bill that will assist the JQC and take care of the problems that may have been some constitutional issues, but now I think we're fine. But the gist of the bill starts on line 63 on page.
Let me be sure we all got the same one. It's LC 294683S.
Yes, sir.
Thank you. I'm sorry. Go ahead.
What it does here on starting on line 63 through 69, just wants the current term of a appointed magistrate, not the chief magistrate, just the ones that the associate. After their terms expire starting July 1st, 2011, they will then start going to one-year terms, and the JQC, Jeff Davis, who's up here with me, who's the head of that, had one suggestion on line 67 after the word year period, subject to reappointment pursuant to this subsection, such one-year term shall commence on the day after the expiration of the current term. But basically, it just makes the associates one-year terms. This was, I believe, one of the suggestions brought up by one of the chief magistrates that testified, Judge Moss, the other day. That was one of the things that she brought up also.
Thank you. Ms. Davis, you like to weigh in on this?
I would certainly appreciate weighing in a bit on it, just to give some context to members of the committee. Mr. Chairman, it's good to be back here today. Those of you who weren't in the Jacobs subcommittee, and give you a little bit of perspective of what's going on here. I'm the new director of the JQC as of September 1st last year, and one of the issues that we have addressed first is obviously our increasing caseload, which is exponentially increasing over last year. When I was before the committee last week, I told you that our caseload, our docketed caseload, is up about 400% over last year. We are doing a lot more with less. One of the issues that we have, because our funding has stayed pretty static over the last 10 years, one of the issues that we have had is there seems to be an inordinate amount of complaints against magistrates who have been appointed by chief magistrates. And what we're seeing is a situation that really starts as a personnel issue. The chief magistrate, the way the current law is in 1510-20, when a chief magistrate appoints an associate or a magistrate under the code section, that magistrate effectively has a 4-year term and can only be removed for disciplinary reasons by the JQC. But what we're finding is there's a lot of magistrates who've been appointed, an inordinate amount, who have kind of gotten sideways with their chief, and for whatever reason. And there's personnel issues that then elevate to insubordination with the chief, and in some cases where the magistrate's not even coming to work anymore. And then that elevates itself after time to a disciplinary matter, and sometimes very publicly elevated, such that the public confidence in the judiciary is really what is at stake here. And that's really what this bill is about, is giving the public confidence in the judiciary. And we believe that the bill, as it's currently reached a metamorphosis as it's here today, the initial proposal was a termination proceeding, which was kind of inverse of the proceeding that places the magistrate on the bench with the consent of the Superior Court judges. There was some reticence on the part of Superior Court judges getting involved in personnel issues with the magistrate court. So the bill that is before you today really is, I believe, a nice compromise with the magistrates who I know are concerned about this bill. And I will say this too, that magistrate judges who are appointed are the only class of court in Georgia that have these protections. Every other appointed judge in Georgia serves at the pleasure of the appointing authority that appoints them. And we realize at the JQC that a lot of the things that the magistrate court does are certainly of significant nature, arrest warrants, search warrants, and things like that. And so I believe that this particular bill that's before you today still gives and empowers the chief to appoint, with the consent of the Superior Court, to appoint a magistrate, but also now ensures that that particular appointed magistrate comes up for reappointment every year, again with the consent of the Superior Court. So we believe this is a nice compromise. It's actually one of the compromises that Judge Moss, who testified earlier this week on behalf of the Council of Magistrate Judges, suggested that it might be that we could shorten the term of the appointed magistrate judge, so that when we have a judge who's in office, we don't have to wait 4 years to do something about it.
Let me ask this, Ms. Davis. Of your complaints that are pending, or giving you the ones handled, perhaps, what are the percentage of them addressing this particular type thing, which is an associate judge magistrate?
Mr. Chairman, right now, I can give you statistics from last year, FY10. Of the 33 cases we had docketed before the commission, 6 of those involved magistrate judges, or 18%. FY11, we have docketed 60 cases as of fiscal year 11, and we have 4 months left. Of those, 20, or 1/3, are magistrate complaints, and 10 of those are associate complaints. So 10 out of 60.
10 out of 60, so
about 18%.
Okay.
16% of our caseload.
Thank you. Mr. James, do you have a question of the presenters?
Yes, I wanted to get Chairman Bearden to repeat that amendment to me. I think it's already. I think what you said is already handled by the language that's there, but I want to hear that again.
Okay, it would just be on line 67, after the word year, and before the word such, inject subject.
Before the period, right?
No.
Oh, it's a new sentence.
After the period, where you start the new sentence with such, but before the word such,
Yep. A new sentence.
Yes, subject to reappointment pursuant to this subsection, such one-year term shall commence on the day after the expiration of the current term of office.
The concern, Chairman Jacobs, was that the way it's currently written, it's not abundantly clear that after the 4-year term that the other term would commence. It says such one-year term shall commence, which doesn't necessarily tie in the language earlier in this subsection, which says that the chief magistrate shall appoint, again, with the consent of the Superior Court judges. So it's the idea that subject to reappointment pursuant to this subsection, such one-year term shall commence. So it assumes at the end of the current term of the magistrate that they would be subject to reappointment before the one-year term would commence.
Okay.
Just a clarification. It's probably covered
I
in
think
here.
I think it's covered.
Okay.
And I actually think the language of the bill is clear. I mean, the way the language of the bill is structured, I think it's very straightforward that magistrate who's serving on the effective date of the bill, when their term expires, they go to one-year terms and they can be reappointed.
Okay.
Thank you. Yes, sir. Mr. McKillop, you have a question?
I just have a question. You said 16% of the complaints are about associate magistrate judges.
That's correct.
Give me the total numbers of the types of judges in the state, and what percentage of the total number of judges in the state are associate magistrate judges?
Associate magistrate judges probably make up, there's about 1,800 judges in Georgia. Associate magistrates probably make up 300, a little over 300 of that.
16%?
About.
So basically the same percentage of judges you have total as the percentage of complaints you have from associate magistrate judges.
That is true, but the nature of the complaints are the issue, because the nature of the complaints relate to personnel issues and insubordination issues, and are causing the JQC, which is already overly taxed in terms of our ability, with only one investigator and one director, to investigate these particular matters. So it's a question of where our resources being allocated, and the case that is in Catoosa County, which was filed last week, it's a public case, so I can talk about it. The Catoosa magistrate case was a case that really started out as a personnel issue between the chief and his appointed associate. He asked that particular associate to begin working on the weekends, and the associate refused to do so. Then it became insubordination. After that, there were numerous arrests, removals from the courthouse. That particular associate has now been out of the magistrate court since July, hasn't worked, and the crisis, really, the issue is the public confidence in the judiciary. There is a complete lack of confidence in the Northwest Georgia area in the magistrate court. So we have now, if this bill had been in place, that particular chief, at the time, could have waited. He's 6 years. Let's say he was on a one-year term. He's 6 months into his term, which would have started January 1st.
Right.
This event occurred in July.
Does Catoosa have a local law?
Not that I'm aware of.
Do you agree with me, my reading of this, that this bill would specifically preempt all of the local laws for magistrates in the state?
I believe it would, but I think Mr. Jacobs could address that more than I could, but I believe it does preempt.
Unless there's something in local law that is conflicting with this as a general law, I'm not sure unless there's good, well, I think if there's a local, let me finish, that, Ms. Travis, you correct me again if you would. If you have a general law, but you also then have a local law that's already in effect, does not the general law override the local law unless it's specifically excluded?
It does, but the preemption here is only as to the magistrate's term.
Okay.
If you look at line 64, it's only with respect to the magistrate term. So if whatever stuff is in local law, it's not going to be
And further, okay.
It's designed to preempt the local jurisdictions that have done local laws on magistrates. It preempts them down to a year.
If they have a term stated, not completed.
Yeah.
We got several people now that have turned the lights. Ms. Oliver.
DeKalb County does have a local law. It says associate magistrates, which I used to be one, by the way, serve at the pleasure of the chief magistrate.
Mm-hmm.
So if we pass this, what's the impact of that local law?
Well, frankly, before this bill even came to fruition, my opinion about the bill and what it should say is that it should be at the pleasure of. I think that's the way that the matter should be resolved. But this is a compromise bill. But in specific answer to your question, I believe that the way the bill is currently written, it would preempt that. And so it's actually giving those particular counties, like Cobb, also has an at the pleasure of. It's giving some of those chiefs, in a sense, less authority over their court. Now, of course, this committee could provide for that, could provide that to the extent that local law permits magistrates to serve at the pleasure of the chief. You could certainly add an amendment to permit that.
Is this compromise supported by the Council of Magistrate Court Judges and the Superior Court?
We're going to hold that question until I've got someone here from that body.
Okay, thank you.
Let me jump in for a moment, if I, because I had some further or previous exposure to what was coming through, and we had a bill at one point that was coming through that would allow for suspension of a magistrate judge if there was a complaint filed with the JQC. Their working would be suspended, correct? Why do we move away from that?
There was a bill, you're correct, Mr. Chairman, that had come through that said that in the event.
I know correctly. Why we move away from that?
Well, I had some constitutional concerns with it, and I
not
think
removal, suspension.
Right, suspension, because the suspension provisions are actually approved by the court, the Supreme Court. Suspension, all suspension of judges, because this is in the nature of a personnel matter, more of an at-will issue, and that would be a disciplinary matter.
Let me ask Ms. Davis. Do we have within the rule-making ability of the Supreme Court the capability of that court addressing a way of either suspending or removing a calcitrant, for lack of another word, magistrate?
Any judge. There is a provision right now in the Supreme Court rules for the Code of Judicial Conduct that allows suspension of a judge. Why don't we go that way? Well, you would have to show habitual intemperance or willful misconduct in office, and the idea behind this bill is that these are not always disciplinary matters. And really what it does in our agency, because of the fact we have very little funding, we would end up having two trials. We would have to suspend, when we suspend a judge, we have to have a hearing before a special master, providing notice to the judge and a hearing, and that, of course, costs money. And then after we have the suspension, that particular suspension goes up to the Supreme Court, and they either approve it with or without pay, and thereafter we have a trial, another hearing of the judge to either remove that judge. Okay. So it's just not cost effective for us to have two trials. We got
here the ability to one to sit for at least a full year without anything being capable of being done to them, though, with even a one-year term.
And again, Mr. Chairman, this is a compromise. I think at the pleasure is the way I would have drafted the bill, but I'm not in your position.
We got our majority whip, Mr. Lindsay.
And this is about as pure a question as I can ask in terms of not really having an opinion behind it, but just wanted to know, because we've already talked about this once before, and I appreciate that earlier conversation. Do we want to, do we want to preclude local law from being able to have a term for a magistrate longer than 1 year? Is that what we want to do? Do we want to require an outside term at 1 year for everybody? Let me back up. I guess we got three choices here. We have one we could put it in here where we preempt all local laws, including those laws for which, for instance, DeKalb County, in which the magistrates serve at the pleasure of the chief magistrate. I would say everybody's going to be one term. We could have a provision that allows for 1 year or shorter if prescribed by local law. Or we could say 1 year unless local law gives another term, either shorter or longer. And my question to the author and to you is which one of the three are you most interested in?
In a perfect world, I say get everything uniform, because with all these local laws out there, everything's all over the place. And have the chief magistrate and those that they appoint work at their pleasure. That would be the ultimate goal one day down the road. But right now, we're not in that posture to reorganize everything statewide for that election process. Right now, I think, and Mr. Davis can correct me if he sees it different or bring in his opinion, I would say every appointed magistrate should be for 1 year. That way, if there is a problem, it can be rectified. Right now, they may sit there for 6 months as a problem. Right now, they can sit there for 3.5 years or 4 years as a problem. Yeah. And that's a problem for the JQC, this budget, and the taxpayers of Georgia.
I'm just trying to get my hand on
it. And Mr. Whip, I would say that in reference to that, I believe the third option would not be one we would support, because it would allow local legislation to push this out again to 4 years. So
I got some more questions. I want to go ahead and get the other members.
Right.
Is it yours, Mr. Welch waives? Mr. Jacobs, do you have a question?
I'll waive.
You waive. All right. We do have some others who would like to address the committee. I have Mr. Charles Auslander with the Council of Magistrate Judges.
The right side.
Yes, sir. Either side. You've got two of you, or just?
Well, and this is Judge Jeff Davis from Monroe County.
Another Jeff. The other Jeff.
The other Jeff.
The prettier one.
Mr. Chair.
It's a popular Southern name, I think.
Committee members, thank you for your time today, and I appreciate what the other Jeff Davis has suggested to Representative Beard and Representative Jacobs. And I think the magistrates realize that there are problems with the potential problems with any judge. Our council just got the amendment this afternoon. I think Representative Jacobs informed us about it early this morning. So the council itself has not had a chance to look at this issue, but the issue that we had with the other bill that would carry over the previous one would be the preemption issue. 41 counties have enacted local legislation addressing magistrate courts, including Cobb, Fulton, DeKalb, Athens, or Clark County, Henry County. If this preempts what the local governments had set up, then we believe at least those governments should have an opportunity to be heard. As far as Athens, Clark County, and so forth.
Let me just interrupt. I don't mean to interrupt your comments and presentation, but the chair is of the position the bill's not going to be going forward today. But I do want to hear comments about the bill.
Then I have one last thing, Mr. Chairman. A judge is a little bit different than another profession, because you can't just move from one judgeship to another. So when a person decides to make the decision to become a judge, they generally have to give up another career, whether it be an attorney, a practice. And so for counties that recognize the value in there being some stability, to encourage people to enter into the judicial field, they might wish to set a longer term so that a person such as an attorney who would give up a practice would know they would at least be able to work for 4 years, provided they didn't violate the JQC's rules. So I just want to set out that it's a different type of profession.
Yeah, and I understand that. I appreciate the fact that you say if you're going into a full-time associate magistrate position, you've got to cut off yourself from everything else as far as your livelihood. So you're saying I'm taking on a new career, effectively. And if you had clients as a lawyer, you're saying goodbye, clients.
Yes, sir.
No longer have that ability to come back and say, wait a minute, I've been fired or whatever, and a year later, please come back to me. How do you suggest, if you have a suggestion, how would you suggest that there be, and you too, Ms. Davis, a resolution of this concern that we're trying to face as a policy matter of that calcitrant magistrate out there who's difficult, he's not following the directions, and says, I'm not going to work on weekends, I'm going to sit in the jail at night, that's part of your job, but I'm not going to do it.
I think if the JQC if we could look at the JQC rules that would allow earlier suspension. If a magistrate is not working or any judge is not working, I don't understand why they should be paid. Now, that may need to be addressed by looking at the rules themselves, but maybe to provide for an immediate suspension if work is not being done.
Okay. And what do you say, Mr. Davis? Judge Davis, excuse me.
We actually have within our council, we have an internal affairs that had we caught some of these, the one he referred to, it shot through so fast we didn't have a chance to look at it, but we can handle a lot of the subordination type things in our own council.
How would you handle it? I mean, man's got a term.
Through training, and we actually have gone before and talked to them and, showed them how different courts have done things. And we've actually will testify, our internal affairs will go and testify in a JQC hearing against the judge if need be. So that's ways we can help with our own council just internally.
All right. Any questions of the representative of the Magistrate Judges Council? Thank you both, gentlemen, for being here.
Thank you.
I think we've got Mr. Michael Caccaro with the Administrative Office of Courts.
Yes, sir.
Would you like to address the committee?
I just want to express...
Have a seat.
I'm sorry. Thank you, Mr. Chairman, committee. I work on behalf of the Judicial Council, support the different classes of courts and the Supreme Court and the administration of justice. I'm coming forward today to let you know the Supreme Court is willing to take a look at its rules with regard to judicial discipline. It creates the rules for the Judicial Qualification Commission, and it is mindful of the issues that have given rise to House Bill 149, and would appreciate the opportunity under the Constitution to take a look at its disciplinary rules and see what changes need to be made.
What latitude does the Supreme Court have in rulemaking, and I guess what is the constitutional authority to do something about removal of a bad judge?
Well, sir, the Supreme Court is circumscribed by the state constitutional requirement that judges be given due process in disciplinary proceedings. However, the Supreme Court itself, under a provision entitled Discipline Removal and Involuntary Retirement of Judges, is given the responsibility for developing rules of implementation of the rules for removing, to remove, suspend, or otherwise discipline for willful conduct in office or for willful and persistent failure to perform the duties of office. Those are two other provisions that we could travel under to deal with what Mr. Davis terms personnel issues.
Mr. Davis, has this been brought to the Supreme Court's attention? If you would mind, come up here for us. And what I'm trying to look at is what is the appropriate solution here if we have to look at one as a legislative body. What I'm hearing Mr. Caccaro say is that there is within the language of the Constitutional a broadness that goes beyond just a matter of intemperance and being a bad apple.
I've spoken to Justice Thompson, in fact, today about this, and he didn't take a position with me one way or another about it. He certainly expressed his concern about the issue. We didn't have a full discussion about how the court might be able to help us with the situation, but I don't believe my reading of the Constitution is such that we can certainly remove judges for disciplinary infractions under the Code of Judicial Conduct. But that is not what the problem is that we're trying to address.
I understand that, but all I'm saying,
Right.
what he's reading from is not under the constitutional provision addressing JQC, right, Mr. Caccaro?
That is correct, sir.
There's another language you're talking about that gives Supreme Court some umbrella authority as to the oversight of the in-office conduct of judges.
Paragraph 6 of the Constitution pertains to the setup of the Judicial Qualifications Commission and its duties. Paragraph 7 speaks to the duties and obligations of the Supreme Court to provide for the discipline, removal, and voluntary retirement of judges.
All right.
And my response to that, Mr. Chairman, would be, the question is, do we want to empower the chief magistrate with the ability, like probate judges, like the mayor and councils and everyone else, to be able to ask a judge they no longer need their services? Or do we want to go through the process? And I do agree there is a process by which we can go through to remove a magistrate judge that once the insubordination elevates to a disciplinary case. That's exactly what we've done in Catoosa County. We've filed formal charges against that judge. We will not be able to have that hearing until April under our guidelines. We will probably not get an order until May or June. So it's a matter of, this process does deal with, and there's already a process in place where we can suspend a magistrate who is engaging in willful misconduct in office. We certainly can. The question is, do the resources, the precious and limited resources of the JQC, need to be allocated for these types of things, or should we empower chiefs, chief magistrates, with the ability to do that?
Maybe that will. The answer. Final bottom line, maybe that will. You had a question?
Yes, sir, Mr. Chairman. Thank you. How would an associate magistrate judge be released from his or her duties in the case where the workload had just seized up? There were not the number of cases that had previously existed for which necessitated the need of an associate judge.
Right now, under the current state of OCGA 151020, once a judicial position is approved, either by the county commission or the Superior Court, that judicial position is there. So once a associate magistrate has been appointed in a 4-year term, if in fact there is no work, that judge still sits in that position for 4 years, unless the Superior Court decides to withdraw the position.
All right. Thank you. And thank you, gentlemen. I think we're all thoroughly confused. That's what we want to do.
Well briefed.
Well briefed and confused, yeah. We're going to, as I say, I'm going to exercise my prerogative as chair to hold any further consideration. Mr. Beard, I hope you understand, trying to get the right answer here just keeps, it's very mercurial moving around. So we're trying to find the right answer. And this sort of came up without my having time to digest that idea, but we'll look at it and may come back with an at-will situation. Who knows? But thank both of you. I want to go ahead and put this aside, and we've got one last bill. Come on over. I'm sorry, Rusty. This is a good bill. You're going to take the adjourn.
Absolutely.
Very short bill. Move to adjourn. I think I heard.